What is a refusal to deal under Section 1 of the Sherman Act? Remember, this requires some combination or contract restraint of trade. So market competitors get together and refuse to deal with someone else in the market. Generally, this involves a supplier or a buyer. You boycott them and refuse to deal with them. And that can have a anti-competitive effect, particularly if there's an intent to have some anti-competitive effect in the market or to at least give some pro benefit to a particular market participant, then this collaboration between otherwise competitors can be anti-competitive. Now, if there is not an intent there to create exorbitant amount of power within this one buyer or supplier, or to put another competitor particularly out of business, then they would evaluate, the FTC or the court would evaluate the situation under the rule of reason. Again, is this refusal to deal, is there a justification there? That is a market justification. Does it have something to do with available technologies or something of that nature? So to give you somewhat of an example, so say a manufacturer or a couple of manufacturers were to get together and agree to boycott a particular supplier, okay? If the purpose is to put that supplier out of business or to give an exorbitant amount of power to another supplier, then again, you're looking at an intent towards per se illegality there. But if there is no intent there, it's specifically to make certain there's enough supply of goods, for example, through a combination or combined buying agreement that's not meant to cause a price disparity or diminish the availability of a product there, then while it may have any competitive effects, then it wouldn't fall under per se illegality. It would be more of a rule of reason application to the situation to determine to what extent the anti-competitive aspects weigh or measure against the pro-competitive justifications.